All right, well, good morning, everyone. It's a pleasure to see all of you, and I appreciate the invitation. And thanks to Matt for giving us a nice, good nap, so we're all rested and ready to talk about new legislation. I have to say my feelings are a little bit hurt. I was told that the auditors did not want me to talk about deductions twice in the same year. So I guess deductions will wait until fall, and we'll talk about new legislation this spring. But rest assured, we will touch on deductions as part of this presentation. And I do realize that I'm the only thing between you and lunch, so I'm going to try to keep it within my hour. But of course, we start a little bit late, so please bear with me. All right, so this is just a general overview of what we'll be talking about in the context of new legislation. Obviously, not all of this impacts county auditors directly, but I think it's helpful to have a good overview, a good working knowledge of all the legislative changes, even if they don't directly impact you. We'll start with assessment issues, and House Enrolled Act 1294 introduces a provision whereby if public funds are used to renovate or rehab a building, and after the completion of the project, a private party will own the property has to be reassessed at the completion of that project. I'm not exactly sure what the need for this was, because I think it's already the case that when a building permit is pulled and work is done on a building, the property is reassessed by the assessor. But I think there was probably some concern that because public dollars were involved, that maybe the properties weren't being properly assessed or timely reassessed. So again, a new provision, I think more relevant to the county assessor. All right, big box store assessment. I think this is something that's probably very familiar to all of us. And this really involves the assessment of your Targets, your Meijers, and so forth. And there's been a lot of controversy about that, and it's becoming a more national issue. So the General Assembly did respond to this. This is actually the second session in a row where they tried to address this issue. And we now have this concept of market segmentation. And it's a framework. It's something that our agency will be working on. We'll probably be developing something through our real property guidelines or through our rules. And it is a long-term project, and we are looking into that. But the idea here is that when you're assessing a property, valuing a property, and you're using the sales comparison approach, you have to look at the sales of properties that are in the same market or sub-market as that subject property. In other words, you have to compare apples to apples. So, as I said, we are working on a framework here, but in the meantime, parties are not prohibited from developing their own market segmentation analysis and using it as part of their assessment appeal. Now, personal property audits. Here the county assessor now has a little bit more discretion in determining when to pursue the audit of a personal property return. Basically, if the assessor considers the examination and verification of that personal property return to be useful to the accuracy of the assessment process. And the same discretion is extended to the contractor that the assessor has. And there was initially, I think, a more dramatic overhaul to personal property assessment return auditing, but this is what they ended up settling on, and it's a little bit more, a little bit softer than I think where they were initially heading with it. Now, agricultural issues, there was some attention given to agricultural matters. First off, the soil productivity factors used for March 1st, 2011 will continue on for all future assessment dates. Also, there was a change to the formula used to develop the base rate for agricultural land. And the base rate for January 1st, 2016 for that assessment date is $1,960 per acre. And on this slide, you can see what the new formula is. So not exactly something you can just hammer out in a couple seconds on the back of a napkin. It's a little bit more difficult here, a little bit more challenging, but that is the new formula. And the idea here is to try to ensure some stability in agricultural base rate values. Over the last 10 years, they've been steadily creeping up quite significantly, and I think at some point within the next year or two, they were going to be, I think the base rate was going to be around $3,000 or more. So this new formula, I think, is geared toward creating some stability and to ensure that they don't jump or dip dramatically. Now, with regard to Wildlands, windbreaks, filter strips, native forest land. This type of land had historically been assessed at $1 per acre, and I think that dollar per acre rate had been in place since the 1920s. They came in this session and they updated that. It's now $13.29 per acre, and I don't know how exactly they came up with that figure, but there is now this indexing that's been implemented so that with the passage of time that base rate will go up a little bit. All right, moving on to the topic of appeals. Some changes here. First off, House and Rule Act 1068. If a taxpayer, if their exemption application is denied by the Property Tax Assessment Board of Appeals, the taxpayer has 45 days rather than 30 days to seek review by the Indiana Board of Tax Review. Also, if the PTABOA fails to approve or disapprove the exemption application within 180 days of the filing of the application, the owner can seek a direct review by Board of Tax Review. And also, if a person files a correction of error appeal, this is a Form 133 appeal, and the PTABOA fails to make a determination within 180 days of the date of filing, likewise, the taxpayer can seek a direct review by the Board of Tax Review. There was already an existing mechanism like this for Form 130 assessment appeals, but there was nothing for correction of error appeals, but now there is. All right, the Property Tax Assessment Appeals Fund. This is something that was first introduced in 2015, didn't actually take effect until the beginning of this year, and in this past session, they made some refinements to it. This is basically a fund, an account that can hold dollars that are transferred out of other funds at the county or the other unit, whatever the unit may be, city, town. The unit can transfer its dollars out of those other accounts into this Property Tax Assessment Appeals Fund, and those dollars can be used to help the county assessor defend appeals, property tax assessment appeals. So again, this fund will not have its own tax rate. It's basically an account to hold dollars. It's optional. You don't have to establish it. You can. It's discretionary. If you do establish it, again, it's discretionary in terms of transferring dollars into it. And here's just a little more detail on this. Again, the money in the fund can only be used to pay for expenses the assessor incurs in defending an appeal of property located in the taxing unit and for refunds resulting from a property tax appeal. So again, it's to help the assessor defend those appeals because they can get costly, and obviously some taxpayers have a lot of attorneys and other parties involved, and so the appeals can get expensive. And also the fund can be used sort of as a cushion if a refund has to be issued. The unit then has some dollars to fall back on. Now, money transferred in the fund is not considered miscellaneous revenue, and levy excess, genuine levy excess, has to be treated as levy excess. Now, something else that counties have a unique option here. The county fiscal body, the county council, can adopt an ordinance that would provide the county assessor with some reimbursement for uncommon and infrequent types of appeals. So if there is this uncommon and infrequent type of appeal, the county council can adopt this ordinance, and it would then require the auditor, would require you, to intercept tax receipts that would be collected in the taxing district where the parcel is located, and then direct that money to the assessor to defend that appeal. So again, this is optional. It's the discretion of the county council. I think this contemplates, again, those big box store types of appeals where you have, in the taxing district, you have some massive taxpayer and you've got millions and millions of dollars at stake. The idea here is that the county council can have the auditor intercept some dollars going to that taxing district and then use that money to help defend that appeal. And just to be clear, the unit whose tax dollars have been intercepted cannot turn around and appeal to us for a shortfall. That's not an option here. All right, appeals by holders of tax sale certificates. This is a new statute here. A person who holds a tax sale certificate does not have an interest in tangible property for purposes of obtaining a review or bringing an appeal of an assessed value. So this makes sense. If you're holding a certificate, basically you're just holding a lien on the property. You're not quite the taxpayer yet, and so you don't have the ability to file an assessment appeal. Now, I have several slides on this topic here, the creation of multi-county PETA-BOAs. I'm not going to go through every slide, but the information is here. We've also released memos on actually all of these topics. We've released memos, including the multi-county PETA-BOA topic. So that information is out there if you want to access it, but for the sake of time here, I'm not going to go through each slide. But the idea here is that counties can agree to form a multi-county PETA-BOA, and this will help theoretically to clear up some backlog that counties may have, or if one county has some difficulty finding qualified people to serve on the PETA-BOA, this might help alleviate that problem. But again, it is optional, and legislation is effective January 1st of next year. So I'm going to jump through some slides here. All right, and by the way, does anyone know what the definition of mixed emotions is? It's watching your attorney drive over a cliff in your new car. All right. They don't get any better, so just... All right. As I promised, we will be talking about deductions as part of this presentation. There was a fair amount of action on deductions this session. So we'll start with veteran deductions. This was Senate Enrolled Act 304, did a lot of work on veteran deductions. First, the totally disabled vet deduction. And I want to emphasize that this change takes effect January 1st, 2017. So this will first impact the 17 pay 18 cycle. So first off, the assessed value threshold for this deduction has been raised from the $143,160 up to $175,000. Also, that threshold only applies to the vet's Indiana real property or his personal property, mobile or manufactured home. So if he has, let's say he has some depreciable personal property tools for his business, you would no longer count that assessed value toward that threshold. Or let's say he owns a house in Florida. You would not count that or consider that toward the threshold. It's only Indiana real property or his personal property, mobile or manufactured home. And again, this is the deduction for vets who are totally disabled, doesn't have to be service-connected, or they're at least age 62 with a disability of at least 10%. Again, does not need to be service-connected. And again, that 17 pay 18 cycle. This theoretically should make the deduction available to a greater number of disabled vets. Now, there's an entirely new deduction for disabled vets, and again, this is effective January 1st, 2017, so this is the 17 pay 18 cycle. And this is for vets to whom a homestead is donated by a nonprofit, basically. So again, this is a vet who's at least 50% disabled. He served in the military for at least 90 days. He was honorably discharged, can provide proof of his disability. And the homestead was conveyed by probably like a Habitat for Humanity or maybe a Wounded Warrior Foundation, one of those types of organizations. Now, the amount of the deduction corresponds to the amount of disability that the vet has. So I think there's kind of a floor here of 50%, and it can go all the way up to 100%, just depending on the vet's disability. And again, homestead here, it's the same meaning as for the homestead deduction. So it's the dwelling and the immediately surrounding acre. So if you have, I guess if as part of the donation, if you have 30 acres of land that was also donated, this deduction will only apply to the homestead portion of that property. And to be clear, a vet who receives this deduction cannot also claim a partially disabled or totally disabled vet deduction. You would be limited just to this donated homestead deduction. Also, if any portion of the deduction is not used, he cannot apply that toward excise tax. I doubt that he would be in a situation where he had an unused portion of the donated home deduction, but I haven't crunched numbers to see if that's theoretically possible, but just want to make that clear. We will be updating our disabled vet deduction application form. We'll probably be doing that toward the end of the year. Obviously, we don't want to do it too soon because the deduction isn't available until 17 pay 18. Now, the homestead deduction, still kind of in the same vein as talking about veterans or soldiers. As you know, it's a general rule of thumb that if somebody is absent from their homestead for a period of time, they can continue to claim the homestead deduction so long as they have the intention of returning to the homestead after the absence, and the homestead is maintained as their homestead. In other words, it's not rented out. There was a provision added to the homestead deduction statute a couple of years ago that dealt with soldiers who were deployed out of state. And that provision said that that soldier could continue to claim the homestead deduction even though he's been deployed out of state, so long as the property is not rented out. Well, they went back in and they changed that, and so now it is possible for that soldier to rent out the home, and he can continue to claim the homestead deduction so long as he lived at the property at any time during the past 10 years. So again, this provision, I think it's fairly narrow in scope. It's going to involve a soldier who's been deployed, is an active service member, he's been deployed, rents out the homestead. He can continue to claim the homestead even so long as he lived at that property at least once during the past 10 years. Now, there were some other very hyper-technical changes made to the homestead deduction statute that aren't even really worth repeating here. I just want to put that out there in case you happen to read through these bills and you see something else. They're just very technical changes. All right, now this should be a favorite of everybody here in the audience, the ineligible homestead deduction procedure. Some changes here. This is effective July 1st of this year. Auditors will now have the discretion to seek taxes and the penalty corresponding to an ineligible homestead deduction. And if you do choose to seek those taxes and penalties, you must do so within 3 years when the taxes were first due. So again, effective July 1st, you have the discretion. You don't have to seek those back taxes and the penalty. If you choose to do so, you're limited to 3 years when the taxes were first due. There was some ambiguity as to how far back an auditor could go under the old version of the law, and now I think it's made very clear. Now, this is some language that we did not request. It was stuck in at the very last minute by some of our good-hearted legislators, but I'm not really crazy about this language here. Maybe next session it can be tweaked. But if you do choose to go and seek those ineligible taxes and the penalty from that taxpayer, there are some constraints on how long that taxpayer has to pay those taxes and penalties. So the statute says that the taxpayer has 1 year with no penalties and interest to pay it back if the taxpayer did not comply with the requirement to return the homestead verification form, the pink form, and the county auditor allowed the taxpayer to receive the homestead deduction in error. So again, I guess the idea here is that if somebody didn't return their pink form to you, I guess the idea is that that person's homestead should have been pulled for failure to file the pink form, and if the county left it in place nevertheless, that taxpayer gets the benefit and has 1 year to pay just the ineligible taxes. They would not have to pay that 10% civil penalty. Now, if the taxpayer did return the pink form and presumably indicated that they were eligible for the deduction even though they weren't, then they only get 30 days to pay the taxes and the penalty. Now, my question is, what happens if somebody did return the pink form to you and they wrote in the corner, please remove my deduction, I'm not eligible for it? Where do they fall in this? Because technically they did return the pink form, but they did so to say that they weren't eligible. So under those circumstances, I would probably just let it go, just not go after those taxes. But if you want to go after the taxes, then I'd probably give that taxpayer the year to pay them back, since the taxpayer did make the effort to notify you of their ineligibility. And this slide, I think, it provides a kind of an example of a hypothetical of how this would play out, and I won't read that verbatim. But I do encourage you to look through the statute as it's been amended, or look through House Enroll Act 1273 and look at the changes and try to become familiar with them. Obviously, it is a complicated matter. All right, now, we already know that property owned by a trust can receive certain deductions. And I don't want to get too deep in the weeds because it gets a little bit confusing, but that has not changed. A property owned by a trust can still have certain deductions on it, basically so long as the person with the beneficial interest in the trust timely applies for the deductions, and is otherwise eligible. And that's kind of the bottom line here, but just wanted to point that out. And to be clear, property owned by a trust can have the over 65, the blind disabled person, partially disabled vet, totally disabled vet, standard homestead, supplemental homestead deductions, and even the surviving spouse of World War I veterans. That's still with us after all this time. So, all right, now, If your mind hasn't been blown yet, it will be here with the Heritage Barn deduction. I know a perennial favorite of auditors when I come and speak. So this will really knock your socks off here. So these changes are effective July 1st of this year. And basically, I think will really only affect new Heritage Barn deduction applications. I think existing Heritage Barn deductions will largely be grandfathered in. So just think of this in terms of new applications coming in after July 1st of this year. So going forward, the Heritage Barn deduction will only be available for a mortise and tenon barn that on the assessment date was constructed before 1950 and retained sufficient integrity of design, materials, and construction to clearly identify the building as a barn. There is no longer any prohibition against using the barn for agricultural purposes in the operation of an agricultural enterprise or for business purposes. And statute defines mortise and tenon barn to mean a barn that was built using heavy wooden timbers joined together with wood-pegged mortise and tenon joinery that form an exposed structural frame. And that's literally in the Indiana Code, or will be on July 1st. So again, going forward, if someone applies for a Heritage Barn deduction, I think it will really be up to the assessor to probably evaluate if this is a mortise and tenon barn and when it was constructed. And then if it meets these criteria, then you as the auditor would apply the deduction. In this slide, I try to walk through some of this, try to make some sense of this. And again, you know, I think existing Heritage Barn deductions will be grandfathered in. I suppose Heritage Barns that are currently receiving a deduction could start to be used for business purposes because of this legislative change. I don't think they would lose the deduction. Basically, if you look at the way the statute's phrased, only if it's determined that the barn was not built before 1950 is that really the only basis for terminating a Heritage Barn deduction. Likewise, if you have, you know, if Bob is getting the deduction in his name and he sells it to Joe, there would be the carryover for that 1 year in Bob's name, but then Joe would have to apply in his own name for the following assessment day. That's just like any other deduction. So again, it is a little bit tricky. I'm not going to read this verbatim here, but there is a bit of a change there, and if you have any other questions about it, yeah, you can certainly reach out to me. There were some technical changes on the filing window for abatements. Again, I'm not going to get too carried away on this, but basically the filing window has been tweaked a little bit to account for the change in assessment date to January 1st. The previous filing window was really in terms of the March 1st assessment date, and now they've been tweaked a bit to account for the January 1st assessment date. The third bullet point there, I just want to point out something else that was changed. If the designating body fails to set the number of years for the abatement or the abatement schedule, the auditor must return the application to the designating body so it can remediate the error. This is for someone who applies for a rehabilitated property abatement, and if the designating body fails to set the schedule, the number of years for that abatement, then you would just send it back to the designating body so they can do that. I think that's already been how you handled it as practice, but now it's been codified, just to make that clear. All right, the property tax disclosure form, you might recall this, you might not. This was inadvertently left in a bill from 2015. It slipped through. They meant to pull it out at the last minute, but it didn't make its way out. And so it technically became law. So they just went back in this session and they pulled that out. This was a form that counties could require taxpayers to fill out if they were applying for certain benefits, deductions, exemptions, permits, and so forth, disclosing whether they were delinquent in any property taxes. So again, that's been eliminated, and we'll remove that form from our website. There's been a sunset placed on a couple of deductions here, the deduction for rehabilitated residential property and then historic property. That's for structures built at least 50 years before. There's a sunset placed on those. There can be no new deductions granted after January 1st, 2017. Any existing deductions under those statutes will just run their course. All right, shifting on to exemptions. There is a provision here that prevents certain charges and fees being placed on exempt property located in TIF districts. Again, this is probably very narrow in scope, but if the property was located in a TIF district before the designation of the area as a TIF district, or if the property was donated for a tax-exempt purpose, it can't be charged certain fees and certain payments in lieu of taxes. So again, pretty narrow scope there. We have, as I said, there's a memo on this that goes into greater detail. I'm not going to repeat all the details right here. Homeowners Association personal property, you'll recall last year, Homeowners Association common areas were exempted, so the real property has already been exempted, but now the personal property has been exempted, and this will apply for the 16-pay-17 cycle. So this is the Homeowners Association owns some barbecue grills, some ladders, some pool chairs, all of that personal property would be exempt. And again, I think it's just an automatic exemption. I don't think they have to apply to receive that exemption. There was a sunset restriction placed on some exemptions. So this first one here, I think, probably impacts the Habitat for Humanity type organizations. So an exemption granted for a tract of land acquired for the purpose of erecting, renovating, or improving a single-family residential structure to be given away. That is no longer available beyond the January 1st, 2017 assessment date. Again, an existing exemption will run its course. And then restriction here on the exemption for improvements on real property constructed, rehabilitated, or acquired for the purpose of providing low-income housing. So I think the criteria, the eligibility criteria, have been restricted a bit, make that more narrowly available. Airport authority property, the exemption for certain airport property has been expanded a bit. It includes leased property used for agricultural purposes and located in an area that federal law and regulations of the FAA restrict to activities and purposes compatible with normal airport operations, runway protection zones, navigation easements, and so forth. It is now exempt, and this is effective July 1st, 2016, so I think it'll be the 17-pay-18 cycle when that exemption first kicks in. Here's another favorite. This gets everybody excited here, the exemption for personal property with an acquisition cost of less than $20,000. Now, as you'll recall, this exemption was made automatic in the 2015 session, and it required the taxpayer to file a notarized certification with the county assessor, basically to claim the exemption. And there was a great wailing and gnashing of teeth and just, great consternation about this. And I couldn't understand what the big deal was about going to your UPS store or the bank as a taxpayer and getting something notarized, but that's neither here nor there. So this past session, they tweaked the statute, and for 2016 only, taxpayer had the option of either filing the certification or declaring the exemption on the personal property return, the Form 103, 102. Starting next year, so for 2017 onward, the only way to claim the exemption will be through the personal property return. And we've already updated the forms. We did so at least a month or a month and a half ago. And there's a checkbox on the top of the form, and then taxpayer will only have to fill out certain sections of the form and then file it with the county assessor. So hopefully that will make it a little bit easier for both taxpayers and the county to process those exemption claims. All right. We do have some FAQs on this personal property exemption. It's at the link here, and those can be useful to taxpayers or the county if there are any issues about this exemption. Now, Matt already talked about budget streamlining. There are just a couple other things I want to mention on budget issues here. First, the deadline for establishing a unit to ensure levy for the ensuing year, a little bit of a change there. So, in order to receive a tax levy for 2018, the unit has to exist on or before January 1st, 2017. To get a tax levy for 2017, the unit had to exist as of March 1st, 2016, and that's true even though the assessment date in 2016 was January 1st. The deadline for establishing the unit in 2016 is still March 1st. So again, if the unit existed as of March 1st this year, they can potentially get a levy in 2017. To get a levy in 2018, the unit has to exist as of January 1st, 2017. Also, some tweaks here to the excess levy appeal statute. First off, the excess levy for the extension of services to additional persons, that has been eliminated. You can still potentially get an excess levy for extending services to new areas. You can potentially get an excess levy for annexation or consolidation of services. But extending services to additional persons, that language has been struck, and the idea here is that if some people move into the city, just normal population growth, that shouldn't necessarily trigger an excess levy or an increase to the max levy just because of normal population growth. There were also some other obsolete excess levy provisions that were repealed. I'm obviously not going to go through all of those here, but just some things that had long since expired have been deleted. By the way, what do honest lawyers and UFOs have in common? Well, you always hear about them, but you never see them. Oh, come on, that's all I get? All right, school issues. A few things here on schools. First, protected tax waivers. As you know, there are certain funds that are considered protected from circuit breaker impact, specifically debt funds. Schools have had the opportunity already to seek a waiver from protected taxes so that their debt funds can absorb some circuit breaker loss so that they can provide some relief to their other funds, mostly CPF. That opportunity has been extended through Pay 18. There are a couple of caveats here, though, a couple of restrictions here. If a school in 2017 or 2018 issues new bonds or enters into a new lease rental agreement for which the school corporation is imposing or will impose a debt service levy other than to refinance existing bonds or debt that was approved in a referendum, and the school corporation is not eligible to allocate the credits. So the idea here is that if you're a school and you're going out and incurring more debt and kind of exacerbating your circuit breaker problems, then you shouldn't be able to benefit from this waiver opportunity. And I think there'll be more guidance coming out on this because there have been questions that have come up. Well, what kind of bonds? What about common school fund loans? Those I don't think would count as the bonds here, but I think there'll be more information coming as we get a little bit closer to the. I think to probably in maybe later this year, early next year. I think there'll be more guidance on that issue. Also, CPF, the Capital Projects Fund, can still be used to pay for utility services, property or casualty insurance, or both, through January 1st, 2018. That they're just extending that window for using CPF dollars for that purpose. Amendments to the referendum and petition remonstrance process. I technically have this under a school issues slide, and I wish I had done this a little bit differently because this technically applies to, all right, disregard that. This slide is about extending an operating referendum, so this does affect schools only. So schools can have an operating referendum. Obviously, that's used to help supplement their general fund revenue. They can use this for operating purposes. They now have the ability to extend an existing operating referendum. So under the previous version of the law, once the referendum expired or ended, that was it. The school would have to start over. Here they can now extend the operating referendum, and there's specific language they have to use. It has to be put on the ballot and be approved by voters, but it is an option that schools have. This is the slide I was talking about. I have it under the schools issues slide, but it really affects all units. And when a political subdivision makes its preliminary determination to issue bonds or enter into a lease, it's a controlled project, they give notice, and then that triggers the window for taxpayers to request the implementation of the petition remonstrance or referendum process. And now when taxpayers request the implementation of that process, it requires 500 signatures rather than just the 100. So I'm not sure what the genesis for this was because it seems to restrict or make it more difficult to request petition remonstrance or referendum, but it is the law effective July 1st of this year. Now let's say the taxpayers do sign a petition requesting the petition remonstrance or referendum process, and let's say there are 700 signatures on that petition. County Registration Office, once they've verified at least 525 persons rather than 125 under current law, they can stop verifying. They don't have to go all the way through and verify all 700. They can stop at 525. And again, the change is going from 125 to 525. All right, fire protection territory. Some updates here. First involves the incurrence of debt by fire protection territory. A couple of options here. The fire protection territory can, the provider unit of the fire territory can negotiate debt on behalf of the fire territory, and the debt limit of that entire territory would then count, and each unit in the territory would share in that debt and carry the debt burden. Another option is the a participating unit in the fire territory can go out and incur debt in its own name, just on its own, be subject to only its own debt limit. And then that participating unit would own the property that was purchased with that debt, and then enter into an agreement with the territory so the territory can use that equipment. So again, two options there. This is already, I think, how territories have been doing this, or how we've been advising territories to handle this, but it was never really in code, and it was always a little bit murky. So again, it's been codified now, and those are the two paths that the fire territory has. Now, one thing to bear in mind, if the debt is incurred on behalf of the territory, it has to be repaid through the Equipment Replacement Fund, which has a statutory capped rate of 3 1/3 cents. Now, another issue that comes up: what happens if a unit withdraws from a fire territory, or the fire territory dissolves? How do you reset the levies of those units? And this is the way we've been handling it in the past, but again, now it's codified. So the unit will receive a percentage of the territory's max levy equal to the percentage of the assessed value that the unit contributed to the territory in the year in which the withdrawal or dissolution takes effect. So let's say you have a fire territory with 2 units. They each contribute half of the assessed value to that territory, and the territory has $1 million max levy. And let's say the territory dissolves. In theory, what would happen is each unit, their max levy would be increased by $500,000, because each contributed 50% of the assessed value to the territory, and the territory had $1 million max levy. So again, in theory, that's how it would work. The language that was in statute previously was just so unclear, so muddy, unworkable, and now this, I think, will help make it a little bit more smooth. The Equipment Replacement Fund, this is it's basically a cumulative fund that a fire territory can have. It's analogous to the Cumulative Fire Fund. And there was a little bit of a loophole in statute. There was the number of taxpayers needed to object to the establishment of an equipment replacement fund was missing. It wasn't provided for, and now that loophole has been fixed, and it requires at least 10 taxpayers to object to the establishment of a fire territory equipment replacement fund. All right, city park and recreation boards. Change here. The law did not previously allow merely a resident of the school corporation to serve as an ex officio member of the city park and recreation board. So in other words, somebody gets appointed by the school board by virtue of being either a school board member or a resident of the school district. Very technical change there, really only impacts cities. Now, I have several slides on this topic here: disclosure of financial and operational data on Gateway. I'm not going to get too deep in the weeds on this, but this was a bill geared toward greater transparency and access to information through Gateway. There really are no new reporting requirements for units here. This is basically about taking existing information that's out there and consolidating it, putting it on Gateway, kind of reporting it in a central location. And DLGF will be doing the heavy lifting on this. I think we'll be the ones kind of consolidating and centralizing the information. So again, it shouldn't translate into additional reporting requirements for you. The one thing I will point out, and this is a few slides down, DLGF has to develop what's called a financial and operational summary. And again, this is something DLGF will put together with existing data. And this is long term here. We're talking summer of next year. So if the unit has a website, the unit is obligated to post a link to Gateway on the unit's website, so a taxpayer can take that link to Gateway and access this financial summary. If you don't have a website, you're not obligated to go and create one. It's only if you already have one you have to post the link. That would really be, I think, the only work that the locals will have to do on this particular issue. But we'll be putting out additional guidance and direction again as we get a little bit closer to that point in time. All right, now, before I depart, there are just a couple of things I wanted to touch on here that have come up over the last few months, and I've promised that I would discuss this at the Auditors Conference. This gets us back to deductions here on this slide. Uh, there seems to be a bit of an issue here where if you've got a spouse who passes away and the surviving spouse quitclaims the property and removes the deceased spouse's name, some counties are demanding that that surviving spouse reapply for the homestead deduction or other deductions. And there's a statute here, and this also applies technically in a divorce situation. If there is a divorce and the ex-spouse retains ownership of the property and the other spouse is no longer there, no longer an owner, this statute says that the party is not required to reapply for the deduction for the following year, following the removal of a joint owner in the case of a spouse that has died or in the case of a divorce. So again, let's say you've got Bob and Sue. Sue passes away. Bob quitclaims the property and removes her name from the title. Under this statute, technically, Bob is not obligated to reapply for his deductions for the following assessment date. Now, it might be cleanest if he did that because Sue has passed away and it'd be nice not to have her name still floating out there, but technically he's not obligated to do so. And likewise, if Bob and Sue divorce, and let's say that Sue retains ownership of the home, technically under this statute, Sue is not obligated to reapply for the deductions in her name. Now, in that case, I really do think it would be cleanest if she did, because if Bob goes and buys a home and wants to apply for a deduction in his name, then his name is still going to be popping up in the database associated with Sue. So it would be cleanest if she reapplied, and you could certainly ask Sue, would you please reapply? Would you be willing to do that? But if she doesn't, if she refuses to, you can't terminate her deduction if she's otherwise eligible, and this statute is the reason why. So I've gotten complaints from attorneys about this, and there's some inconsistency across the state, and so I promised I would bring this up and discuss it here. Something else that had come up, let's say a sales disclosure form is submitted to the assessor December 31st, but it doesn't make its way to the auditor until after January 5th. Can the deductions still be processed if they've been applied for through the form? And the answer would be yes. Statute just says that the sales disclosure form has to get to the assessor on or before December 31st, and it can constitute a valid application for deduction. So if the sales disclosure form doesn't reach you until after January 5th, that's okay. You can still process those deductions. And finally, questions have come in with a change in assessment date. How does that impact the timeline for applying for deductions, or specifically the mortgage deduction? When do you have to have the mortgage in place and all of that? And I've tried to put together this information here just to give you a little bit of help on kind of the timing. I mean, conceptually, I don't think there's really any change because of the assessment date. Instead of March 1st, you're looking at January 1st. So it's the same procedures, same principles and everything. You're just looking at a different date of the year, but hopefully this provides a little bit of help to you. Now, if you're a new auditor or a new staff member, this is a link to my deductions presentation from last fall, and I would encourage you to review that. I think it might help address some of the questions you have. But certainly, if you have any issues or questions, feel free to reach out to me by email. Is always a bit preferable because it's easier for me to loop in some of my colleagues if I need to bounce some questions or ideas off of them. But that is how you reach me. And I won't let you go to lunch without one last attorney joke. I've got 4 whole minutes. Actually, I think I've got 9, so I might read this slowly here. So a little boy was in a cemetery with his mother. "Mommy," the boy asked, "do they ever bury 2 people in the same grave?" "Of course not, dear," replied the mother. "Why would you think that?" "The tombstone back there said, 'Here lies a lawyer and an honest man.'" All right. Well, thanks for humoring me with your laughter. I appreciate that.